You have 11 days until New Jersey gun owners could legally walk into a dealership and buy a rifle that's been contraband for over 3 decades. And if you think that sounds unbelievable, wait until you hear what just happened one state south, because Virginia already beat them to it. Welcome back, everybody. If you've been anywhere near gun rights media this month, you already feel it. Something shifted, not a rumor, not a prediction. Actual courtrooms, actual rulings, actual dates on a calendar. Today we're breaking down exactly what happened in Virginia, exactly what's coming in New Jersey, and while legal analysts are calling this the most consequential stretch for the Second Amendment in 20 years. Stick around, because by the end of this video you'll understand something most commentators are getting wrong about what comes next. Let's start with Virginia, because Virginia is where this story actually begins. Back in May, Governor Abigail Spanberger signed Senate Bill 749 and House Bill 217 into law, a pair of companion bills that redefined what counts as an assault firearm under Virginia code using a feature-based test and separately capped magazines at 15 rounds. The Justice Department later called this a law that bans the purchase and sale of ordinary semi-automatic rifles owned by millions of Americans. That's not gun rights spin, that's the federal government's own characterization in its lawsuit against the Commonwealth. The ban was set to take effect July 1st. And for about 6 weeks it looked like Virginia was headed the same direction as California, New York, and New Jersey. Then something interesting happened. Multiple lawsuits landed almost immediately, and while one early attempt at an injunction actually failed in mid-June, a second effort didn't. On June 25th, a Lancaster County Circuit Court judge granted a preliminary injunction in a case called Crump v. Katz, brought by Gun Owners of America, Gun Owners Foundation, and the Virginia Citizens Defense League. That injunction didn't just pause the law quietly in one county. A Washington County judge followed with a separate ruling clarifying that the block applies statewide. Texas Gunsync Gun Talk. Here's why that detail matters more than people realize. A single county injunction creates confusion. A statewide injunction creates clarity, and clarity is exactly what triggers dealers to actually start selling again. That injunction is expected to hold through at least the end of December or until the court rules on the merits, whichever comes first. So right now in Virginia, the ban Governor Spanberger signed exists on paper but not in practice. Firearms retailers across the Commonwealth are, in many cases, back to selling exactly the rifles and magazines the law was written to eliminate. Now, before you assume this is over, understand that Virginia's Attorney General has already moved to appeal. The state announced it would take the injunction to the Virginia Court of Appeals just one day after it was issued. That fight is still very much alive, but for the moment, the practical reality on the ground in Virginia is freedom, not restriction. Now let's talk about the case that's sending shockwaves through every gun-banning state in the country, because what happened in the Third Circuit last week is arguably bigger than Virginia. On July 17th, sitting en banc, meaning the full bench of judges rather than a small panel, the United States Court of Appeals for the Third Circuit ruled in a case most people know as Cheeseman versus the New Jersey Attorney General. The vote was 10-5, and the opinion came from Judge Ariana Freeman, with the full set of opinions, concurrences, and dissents running roughly 192 pages. That length alone tells you how contentious this was inside the courthouse. But the outcome is simple to state. The court held that New Jersey's ban on semi-automatic rifles violates the Second Amendment, and it modified the lower court's judgment so the ruling applies to the entire class of banned rifles, not just one specific model. Reason magazine-bearing arms. That last part is the twist most coverage buried. The original district court ruling only protected one specific firearm, the Colt R-15, because that's the gun the evidence in the case centered on. The Third Circuit didn't just affirm that narrow win, it expanded it. The appeals court extended the order to cover the full class of semi-automatic rifles banned under New Jersey law, and then it went a step further than almost anyone expected. The court also reversed the lower court on magazines, striking down New Jersey's 10-round limit as unconstitutional too. Think about what that means. This wasn't a narrow technical win for one gun owner with one rifle. This was a categorical statement that an entire class of commonly owned firearms, and the magazines that feed them, cannot be banned outright under the Second Amendment as this court reads it. Use Court's Reason magazine? So here's where the story gets almost cinematic in its timing. Just weeks before this ruling came down, the Supreme Court had already agreed to hear a nearly identical question out of Illinois, a case called Viramontes v. Cook County, which challenges that state's assault weapons ban. The Third Circuit's decision arrived just weeks after the Supreme Court granted review in that case, a case with the potential to strike these bans down nationwide, and it gets more layered than that. Just 8 days before the Third Circuit ruled, the Seventh Circuit had gone the completely opposite direction and upheld a similar ban. Every other circuit court to reach this question had ruled the other way, which means we now have a genuine circuit split, with the Supreme Court already holding the issue on its docket. That split is exactly the kind of disagreement between federal courts that the Supreme Court exists to resolve. When circuits disagree this directly, the odds that the nation's highest court steps in and settles it for good climb dramatically. Bearing Arms Reason magazine. Now let's answer the question every New Jersey gun owner is actually asking. When can I legally buy one of these? Because a court ruling on paper and a rifle in your hands are two very different things. According to an internal communication sent to firearms dealers, the New Jersey State Police confirmed the Third Circuit's ruling takes effect July 31, 2026, and said the Attorney General's office is developing practical guidance. For residents and businesses, New Jersey's Attorney General's office corroborated that same date directly to reporters, confirming the decision becomes effective July 31st while guidance is prepared for both law enforcement and the public. Interestingly, nobody has fully explained publicly where that specific July 31st date originated, but it's coming from the state itself, not from gun rights organizations trying to hype the moment, which makes it worth taking seriously. The Daily Caller +2. And the reaction on the ground has been exactly what you'd expect after 3 decades of prohibition. Gun owners across New Jersey have responded with everything from disbelief to open celebration, with social media filling up with posts referencing the old recovered from a boating accident joke, owners removing pins from magazines that limited their capacity, and videos surfacing of people firing AR-style rifles loaded with magazines holding more than 10 rounds as acts of defiant celebration. That reaction matters because it shows you something the legal filings can't. This isn't an abstract constitutional debate for the people living under these laws. It's decades of pent-up frustration finally finding an outlet. The Daily Caller. But here's the part nobody's telling you, and it's the twist that should temper the celebration just slightly. New Jersey is not going to roll over. The state has one path left, and it's the biggest court in the country. Given that the Supreme Court has already accepted the Illinois case on this exact issue, New Jersey's most logical move is to ask for a stay, essentially a formal request to freeze this ruling in place while the Supreme Court sorts out the bigger national question. There are 2 separate places that request could land. One is the Third Circuit itself, asking the same court that just ruled against the state to pause its own decision. The other is a direct emergency application to the Supreme Court. Legal observers following the Cheeseman case closely note that a sharply divided 10-5 ruling with a nearly 200-page set of opinions practically invites further appeals, and New Jersey has every incentive to buy time while its sister case at the Supreme Court plays out. So which way does this go? Think about it like this. A stay exists to preserve the status quo, nothing more. It's not a signal about who's going to win in the end, and the status quo looks completely different depending on which state you're standing in. In New Jersey, the ban has been the law for over 30 years, so freezing things in place means the restriction stays up a little longer. In Virginia, the ban never actually took effect because it was blocked before July 1st, so the status quo there is freedom. That distinction is exactly why you could see 2 dramatically different outcomes into states experiencing what looks, on the surface, like the same legal moment. Zoom out for a second, because there's a bigger picture here that too many people miss while they're refreshing court dockets. New Jersey, Delaware, and the United States Virgin Islands all sit inside the Third Circuit's jurisdiction, and all 3 currently have some version of an assault weapons ban on the books. The Cheeseman ruling wasn't written narrowly enough to apply only to New Jersey's specific statute. Its reasoning targets the entire category of semi-automatic rifle bans built on the same legal theory. That means Delaware and the Virgin Islands are staring down the exact same constitutional problem New Jersey just lost on, whether their legislatures are ready to admit it publicly or not. And this is where the national map really comes into focus. Colorado's own assault weapons restriction is scheduled to take effect August 1st. Rhode Island's already kicked in July 1st. States are still passing these bans even as the legal ground underneath them is shifting in real time. Every one of those laws is now built on sand, because the fundamental question, whether states can categorically prohibit an entire class of commonly owned rifles, is sitting on the Supreme Court's docket right now, with a circuit split actively demanding a national answer. So what should you actually do with all of this? If you're in Virginia, understand that the injunction is real, it's statewide, and dealers are largely acting on it, but it is being actively appealed and could theoretically be narrowed or reversed. If you're in New Jersey, mark July 31st on your calendar, but hold your excitement until the Attorney General's promised guidance actually publishes, because a stay request could still change that timeline overnight. And if you're anywhere else in the country watching this unfold, understand that what happens at the Supreme Court in the Viramontes case isn't just an Illinois story. It's the case that will ultimately decide whether every ruling we just talked about today becomes permanent or gets erased. Here's the takeaway I want you to leave with. A decade ago, states passed these bans and courts mostly waved them through. Today, the same category of law is losing in federal appeals courts, triggering statewide injunctions, and forcing state police departments to send dealers memos about when prohibited rifles become legal again. That is not a small shift. That's the legal ground moving under an entire category of gun control in real time in more than one state simultaneously. Whatever happens next at the Supreme Court, the momentum in the lower courts right now is unmistakable, and it's worth understanding exactly why, because the next ruling could be the one that decides this for the whole country. Thanks for watching, stay informed, and we'll keep tracking every filing as this develops.